Hello guys, and welcome to another episode of Dieko Talks Law. This is Olayeni Diekolola Daniels, and on today's episode we'll be talking about the classification of contracts. This particular episode, I would be talking about formal and simple contracts. In my last lecture, I discussed what a contract is. This lecture, I'll be discussing formal and simple contracts. If this is your first time of coming to my channel, please make sure that you click the subscribe button and also make sure that you click the notification bell so that anytime I release a video of this nature, you'll be one of the first set of people to watch that particular lecture. Now, in my last class, I discussed certain cases, as well as this class I will discuss certain other cases. In case you need a case app where you can get all the fact of the cases, the full judgment, if you want to read through them, then make sure that you get Precious Case app. Watch this video for more information. So yes, when you download the app, please make sure that you use my code when you're about to register. It's going to be showing on your screen right now. Make sure that you use it when you're registering. Thank you very much. The way I teach is that, I go through my notes first and then I explain later. Now, when we are talking about classification of contract, I told you that in this particular lecture, we are going to be concentrated basically on the formal and simple, classification of contract. However, we have other class. We have bilateral and unilateral contract. We have express and implied contract. Both of them I'm going to discuss in, individual lectures later. That's in my subsequent lecture after this one. For this lecture, we are talking about just formal and simple contract. So what exactly are formal contracts? A formal contract is a contract made by deed. It is a contract of ancient origin and its validity is gotten from the form that it is made. It is also known as contract made under seal. It must be in writing, signed, sealed, and delivered. Contracts made by deed do not need to be supported by consideration to be enforced in law. Accordingly, the significance of a contract under seal is that it derives its validity from its form. Formal contracts are usually employed in land agreements such as conveyance, mortgage, and gifts. Now we get to simple contracts. All other contracts than formal contracts are classified as simple contracts. They may be in writing or may be oral. Oral contracts are also called parole contracts. Do you understand? Now, the major factor between a contract under seal or a simple contract is that in simple contract, only a person who has furnished consideration can bring an action to enforce the contract. The validity of the contract depends on the presence of consideration. This was reiterated by Skinner CB in the case of RANN versus HUGHES. RANN and HUGHES. Now, Skinner CB said that all contracts are by the law of England distinguished by agreement by specialty. Agreement by specialty, although archaic in language, means in our own modern language contract under seal, and agreement by parole, which simple contract. Nor is there any such third class as contract in writing. If they be merely written and not specialties, that means not under seal, they are parole and a consideration must be proved. Now, basically, we are trying to understand the difference between a formal contract and a simple contract. Now, when you're talking about a formal contract, not everybody in Lagos, Nigeria own a house. So basically, or even if you own a house, you can ask your parents for the C of O. Just tell your dad or your mom that you want to see the C of O. And if you don't own a house, then the contract of lease, that's the lease agreement between the landlord and the tenant, tell your mom that or your father that you want to see that particular contract. Why am I saying this? So that you can basically understand when they say something has been signed, sealed, and delivered. Do you understand? When you are talking about a document being signed, sealed, and delivered, it means that that document must have, number one, been written, obviously. Secondly, it must have been signed, obviously. But there's something that distinguishes a normal contract, that's a written contract, from a formal contract. A written contract is just to write something and both parties sign. That is a written contract. A formal contract has to have been written, has to have been signed, has to have been sealed. Now, there used to be a requirement of being delivered, but that has been taken away by another case. The case is currently showing on your screen right now. That's been taken away. You don't need to deliver. That's like an ancient rule. But when you're talking about something being signed, sealed, what does it mean? You know that red particular thing that you see in most of them, and even in your C of O, that certificate of occupancy if your parents own a house. If no certificate of occupancy, then the lease agreement that you can find from what your parents have given you. You see that red thing that is there? That is the seal. Do you understand? So you see, when you're talking about formal contract, the essence of formal contract is because they are very, very important kinds of contract. It is mandated by law to have those kind of contracts, because as you will see in my subsequent lectures, the reason for formal contract is because of the fraud that some lawyers and some people were doing in the olden days. So the legislature had to rally around to say, you know what, let us make certain kind of contracts, formal contract, let us make them written, let us make them signed, so that where you don't write and sign those contracts, it will be unenforceable. The reason is because at that time, contract of land, as we can see even in today's world, contract of land is something that there is money there. Do you understand? So what people usually do, they will sell land to A, sell land to B, sell land to C, the same land, sell it to D, sell it to E, sell it to everybody. Because it's parole now. Mommy, my child, one rally now, alone 100,000 or 1 million or 100 million. Because it's by mouth. Okay, you give me, I give land. You see, that one has jackpot with the money. He has got to meet another person, jackpot with the money. Then I said, you know what? Because land agreements are such that they are very, very important. Number one, there is money there. Number two, you know, that particular third party cannot know. Do you understand? Whether or not this person is a fraudster. When he comes to say, it's my father, my great-grandfather, they now start telling you stories. Not those Yoruba people that like telling stories. Now start telling you stories of their great-grandfather that owned the land. And then you buy the stories and then give them the money. All to know that that particular person is a fraud. Do you understand that? So that is why they started that particular make sure you write contracts down kind of rule. Do you understand? So all those contracts that are meant to be written, for example, according to section 4 of the statute of fraud 1677, you don't need to know this now, but I just want you to understand there are two types of contract that are to be in writing: contract of land, like I just explained, and contract of guarantee. As the name of the statute is, statute of frauds, to end fraud. Do you understand? So that is the reason we have formal contract. Now, if you know the reason for formal contract, you can distinguish formal contract from simple contract. Simple contract are oral contract or written contract which are not signed, sealed, and delivered. Do you understand? So you can write something down and then say, well, since it's written, it's formal. If as a contract student you say that, you need knock. Take one. Do you understand? What you are supposed to say is that regardless of the fact that it is written, it is not a formal contract except it is written, signed, and sealed. I told you that we've dispensed with the element of, delivery. Written, signed, and sealed. Now, why is it important to distinguish between formal and simple contract? This is it. As Kaina CB has said in the case of RANN and HUGHES, the difference when it comes to law is that when it's a formal contract, you don't need to furnish consideration, which means a person who wants to enforce a contract doesn't need to have performed his duty in the contract if it's a formal contract. But if it is a parole contract, if it's a simple contract or a written contract, then you need to have furnished consideration. So for example, I went to buy phone from Computer Village and then they sold fufu or sold eba to me as usual, and then I did not know until I got home. But luckily for me, when I got back to Computer Village, even though it is 100% not possible, I saw the guy. We both know that you will never see them again, but let us just leave that one side. So I saw that particular person and then I hold his shokoto. My money. and then I dragged him to the police station. Now, can I enforce the contract that he must sell a good iPhone to me, especially the one he showed me at that counter? Can I enforce it? Yes, because I had furnished consideration by paying. But if I had not paid for it, when I collected the fufu, he had not paid for it, maybe it was on loan or something like that, then I will not be able to enforce that particular contract. But if it was a formal contract, regardless of the fact that I've paid for the fufu, regardless of that fact, then I'll be able to enforce a formal contract because it is written, signed, and sealed. Do you understand? When it comes to parole contracts, you cannot enforce them except you have furnished consideration. That's parole written simple contract. Do you understand? But when it's formal contract, you can enforce it. So I can buy a land the moment we sign, sealed, and whatever it is. Even without paying, I can still enforce the contract in court. Even without paying. I've not paid yet, but I can enforce it in court. Do you understand? The other party too has not delivered the land to me yet he can enforce it in court. He can enforce the agreement in court that you signed and sealed it, which means that you must pay me my money, whether or not he has even delivered the possession. Do you understand that? So that is how it works. At this stage, you are still at the beginning to understanding contracts. So I think that this is, the best for you to understand. In my next lecture, I'll be talking about other classifications of contract. I hope you enjoyed this lecture. Please make sure you click the like and subscribe button. And also for the assignment, in my next subsequent set of classes, I'll give you assignments on this particular subject matter. I will see you in my next class.